10 seconds, 5 seconds, start. Writ petition number 50 of 1998 was filed by the Bhopal gas sufferers as a public interest litigation under Article 32 of the Constitution. This petition was founded on the rights available to the victims of the Bhopal gas disaster under Article 21 of the Constitution, and it was prayed that they were entitled to receive free and proper medical assistance from the respondents, the Union of India, and the state of Madhya Pradesh. It was also prayed that the respondents be directed to take effective steps in that regard, which inter alia included providing of free medicines and preparing a detailed plan of medical rehabilitation that ensured the availability of basic medical facilities to the gas victims. Lastly, it was also prayed that the ICMR be directed to resume and conduct research studies and to make public the reports published by it so as to provide the basic ground for issuance of appropriate directions by this court. This court has been passing various directions right from the filing of this petition and has directed certain effective and positive steps to be taken by the Union of India as well as the state of Madhya Pradesh to ensure providing of appropriate medical treatment to a gas victims. It is no use referring to a different order passed by this court from time to time in detail. However, we will be referring to some of the important orders in brief which have a bearing on the issue now pending before this court and for passing of the final directions. To begin with, the ICMR had undertaken certain research works immediately after the Bhopal disaster, and appropriate steps had been taken as claimed by the state and the central government to deal with the medical problems of the gas victims. However, it appears from the record and has been averred before us that after 1994, the ICMR allegedly took an irrational decision to disband all Bhopal gas disaster related medical research. It could never be said that one who tops the list is equal in merit to the one who is at the bottom of the list, except that they are all mentioned in one list for the purpose of appointment. The borrower, instead of complying with the said order, preferred appeal number 267 of 2005 before the DRAT, which admitted the appeal and passed the following interim order. Pending passing further orders, the appellant shall deposit a sum of rupees 7 lakhs directly to the first respondent bank. However, there shall be stay of implementation of the order in favor of a second and third respondent. It is apt to state here that the appeal was directed to be posted. The bank filed a reply before the DRAT highlighting the consistent default by the borrower, the auction purchaser. The third respondent herein did not file an appeal before the DRAT but filed an application under section 151 of the Code of Civil Procedure.